So the Supreme Court ruled recently against the Trump administration in their efforts to derail DACA, and the case got a lot of coverage. Receiving far less coverage were three cases that came after that decision in different courts. And Chris Hajec, we had one of them was Make the Road New York v. Wolf in the D.C. Circuit Court of Appeals. What was the issue in that case?
That is a very important case because the court restored Trump's expansion of procedure expedited removal to full extent across the country. Expedited removal has been around for a while, for several decades, and it allows the immigration officials to remove an alien quickly if certain conditions are met. And the law allowed the president, in his discretion, to expand expedited removal so that it includes the entire country and all aliens who cannot show that they are, who are here unlawfully and cannot show that they have been here continuously for 2 years. So it's a very important power given the huge number of illegal aliens there are. Until recently, it was limited to within 100 miles of the border, and they couldn't show that they'd been in the country for 2 weeks.
Mm-hmm.
But Trump expanded it to cover 2 years and the entire country. And of course, he was sued over that, and the district court held that he didn't have that power. And he abused his power when he extended it. But the appellate court found that he had complete discretion to do so, conferred to him by the statute, and it wasn't reviewable by a court. It was committed to agency discretion.
Mm-hmm. So this concept of expedited removal expanded. Is that kind of a new thing? Has any other president attempted to introduce that concept as a way to reach this goal?
They've never expanded it this much. They've been using it a lot within 100 miles of the border, but this is an immense expansion beyond that. And it just cuts down on all the procedures that have to be followed to deport an illegal alien, provided that they can't prove that they've been here for, continuously for 2 years.
Mm-hmm. Now, the Immigration Reform Law Institute submitted a brief in support of the administration's position there. How many other briefs were filed in that case, and which side did they fall on?
Well, dozens of lawyers and groups filed briefs in that case, and they all supported the plaintiffs. Only our brief supported the government.
So IRLI is the only voice out there basically supporting this position in filing briefs.
The only voice aside from the government's, yes.
Yeah.
In so many cases.
There's so many groups. I think you said there were dozens. How many groups are there out there advocating for this kind of anti-borders position? And are they well funded? What do we know about them?
There are hundreds of groups, at least, maybe thousands. They are very well funded, and they wouldn't exist without that funding. It often comes from George Soros or people or foundations like that that have an agenda and want to see a broken immigration system, and probably also want high levels of immigration so that one party gets more votes than the other.
Mm-hmm. Well, I think people need to understand that in terms of choosing organizations to support, because you've got this incredibly well-funded movement on the left pushing for these things, and IRLI, as you indicated, is kind of one of the very few voices out there pushing against that. So I think people need to keep that in mind when they look at things out there and who they want to support, because this is one of the few voices out there that's advocating for this.
Right, and that our side is vastly overspent by the other side.
Right. Now, the other case we had was Gomez v. Trump in the Federal District Court for D.C. What was going on there?
That was a case, a challenge to Trump's immigration ban. As a result of all the COVID-19 lockdowns, unemployment has just skyrocketed. So Trump, to protect American jobs, banned the issuance of green cards abroad. And he did this under a very specific provision, a very powerful provision of of the Immigration and Nationality Act that gives him the power to suspend the entry of aliens, of any class of aliens, or even all aliens, if he thinks doing so is in the national interest. And a group of U.S. green card holders who had left their children behind when they came to America sued, saying, because they're not issuing green cards abroad, our children who are now about to turn 21 won't be able to get their green card under the preferential treatment they get when they're under 21 and their parents are in the U.S. and they'll be too old and they'll have to join a much larger group of green card seekers and may never be able to come to the United States. Mm-hmm. The court found that actually in the proclamation, there are waivers you can get in the national interest and that the plaintiffs hadn't shown that this consequence really would happen. So the important thing about that case is that the court did not weaken Trump's proclamation or his power to issue such proclamations. Mm-hmm. And so far, no court has.
So like a lot of things President Trump is doing in the immigration field or area, as well as many others, he's getting lots of pushback and criticism on these things. And they're saying that he doesn't have the right to do the things he's doing. What is the legal basis for President Trump's authority to act on matters of immigration as it relates to high unemployment?
It's this provision, 8 U.S.C. Section 1182F. And it was passed in 1952, and they debated it, whether they should give the president such broad power to, and by the way, he already has inherent authority in foreign affairs. So he probably would have this power even if there weren't specific law about it. But they debated whether they should confer this power on him. And in the debates, the representatives said, this is a very broad power. It just allows the president to shut down immigration. Do we really want to give him that broad a power? And, so they thought about it. They knew how broad it was. And in fact, one of the justifications for it was given as, well, in the future, there might be a time of great unemployment. So the president should be able to stop the entry of aliens competing for American jobs. And with that in mind, they passed it. So he has this power. It was challenged in the travel cases a couple years ago. And the Supreme Court upheld it and noted how broad it was. And it said at most it was subject, and it didn't say it was subject to this, but at most a court could review a proclamation excluding aliens for rational basis. Is the objective of the suspension plausibly related to the suspension? So when Trump says, I'm excluding aliens to protect American jobs, does that have a plausible relation to excluding aliens? And not only is it plausible, it's what Congress specifically contemplated as a legitimate reason.
Yeah. It seems like, Chris, in a lot of these cases, the other side, the anti-diverse side, is operating from a principle that foreign nationals have some sort of right to come here. Is there any legal basis for that? What's their argument why that should be the case?
Well, I'm sure they would. No one, I think, argues directly that there's a right to immigrate to any country, including the United States. But if you analyze their arguments, it often seems like they are contending for something like that. In a recent Supreme Court case, a decision that was very much on our side, case of Trump versus Theresa Guillen, they tried to use, the Ninth Circuit had tried to use habeas corpus as a mechanism for letting people stay in the country. And what the court pointed out is that that's not what it's supposed to be used for. That case was important for two reasons. First, it would just clog up the immigration system even further if every time an asylum seeker had his credible fear, had executive officials decide that his fear of persecution was not credible. If every time such an asylum seeker had that happen, they were entitled to go to federal court and wait years for the federal court to review that, it would just become incredibly more clogged than it even is now. So what happened to Mr. Theresa Guillen was that He entered the country. He was immediately caught by Border Patrol. He claimed persecution in his native Sri Lanka. And he didn't mention anything about persecution by the government because of his protected group or anything of that kind. And he just said he was beaten on one occasion. And the Border Patrol officer found that not a credible fear. His supervisor agreed it wasn't a credible fear. And an immigration judge reviewing it agreed that it was not a credible fear. And those are the three levels of review you get under the law passed by Congress, in the Asylum Act. But he said, well, habeas corpus, I want more. I want to go to court and have them decide whether my fear is credible. And as the Supreme Court pointed out, that would have taken years. And this is the second reason the Supreme Court's decision is important. Many aliens in detention bring habeas corpus actions, but the purpose of habeas corpus, the only relief you can get under it, according to Justice Alito, and this is true historically, is release from unlawful confinement. But aliens in detention can always get release from unlawful confinement. They can just go back to their home countries, and if they do, they might have to give up their immigration claim to go back. But what they're asking for is not release from confinement. They're always asking for release into America, which is different from release from confinement, or they're asking for release without having to give up their immigration claim. Or as in Theresa Guillem's case, he was just asking for extra review of his credible fear claim. And all those things, certainly that is outside the scope of habeas corpus. And I think it's an implication of the case that it's not really been noticed yet, is that all of these habeas actions are not, according to the court, good habeas actions. They're not really seeking release. They're always seeking something else.
Mm-hmm. Now, and Chris, this case you're talking about, this is the third one we were going to get into, the third victory for the pro-law and order side, I guess you could say. Is it true that was a 7-2 decision?
Yes.
Yeah, and it should be noted, this is the Supreme Court now. This is not a lower court. The liberal wing of the Supreme Court usually votes together. So that means they had two of those justices voting for the majority side. What does that tell you about the merits of this case, that they were able to get two of the liberal justices to switch, to break ranks, essentially?
It tells you that the merits are very strong, and the Ninth Circuit had really gone out on a limb, as they frequently do, and had just made up an effective right to immigrate out of a different reading of the habeas corpus writ that had never been applied by any court.
Right. There's a lot of sentiment out there, I think, in the public that the courts are just going crazy, that they're just ruling for every open borders side in these cases. But I think, what we've illustrated here is there are victories taking place. There is evidence that the courts have not gone completely off the deep end, that they are making decisions that support the law and order position. What do you think about that?
I think they are, but one of the reasons for the impression that the courts have been going crazy is that the plaintiffs and their attorneys have been very good at selecting courts that will be friendly to them, like the Northern District of California, or sometimes the Southern District of New York, and other courts, and that's where they've gotten their big injunctions that then are overturned on appeal. And the Supreme Court has been, by and large, on our side, though with disappointments, such as their failure to take cert in United States versus California. But that's just a postponement, and the issue of sanctuary cities and how they are preempted by federal law will come up there eventually.
Mm-hmm. Are there any cases on your radar in the near term that are coming up that are going to be big immigration decisions at any level that you're following?
Yes, it's going to be big in the in district court in Texas, where DACA is being challenged, and Judge Hainan has in an earlier case struck down DAPA, and the issues are almost identical. So it seems likely that he will enjoin DACA, and that'll be appealed. It seems likely the Fifth Circuit will uphold that injunction. And then I don't know if the Supreme Court would take cert or not. If they didn't take cert, the injunction would stand. And if they did take cert, yeah, I would think the votes are there to uphold.
Mm-hmm. Okay. Well, Chris, as you know, our opinions on these cases, our briefs on these cases are all viewable at the IRLI website, which is www.irli.org. And you can also see our content on Facebook, on Twitter. So I want to thank you for sharing your thoughts with us today, and we'll talk to you next week.
Sure. Thank you, Brian.
All right, Chris. Thanks a lot.